Question 1. Cost-benefit analysis shows that a swift settlement of a potentially large liability claim, even with some ambiguity regarding the insured's direct fault, could prevent protracted legal disputes and associated defense costs. However, the insured's business operations could be significantly impacted by the negative publicity and potential for future claims arising from the incident, which approach best aligns with the principles of responsible claims management and regulatory expectations for commercial general liability specialists. Option A. Proceed with a settlement offer that acknowledges the potential for significant loss, contingent on the insured implementing enhanced risk management protocols to mitigate future occurrences. Option B. Initiate a prolonged and exhaustive investigation, delaying any decision on settlement or denial until all possible avenues of inquiry are exhausted, regardless of the impact on the insured's business. Option C. Deny the claim outright due to the ambiguity of the insured's fault, advising the insured to pursue their own legal recourse. Option D. Offer a minimal settlement amount that covers only the most obvious and undisputed damages, leaving the insured to bear the burden of any further losses or legal defense. Correct answer is A. Proceed with a settlement offer that acknowledges the potential for significant loss, contingent on the insured implementing enhanced risk management protocols to mitigate future occurrences. Explanation: this scenario presents a professional challenge because it requires an underwriter to balance the immediate financial implications of a claim with the long-term reputational and regulatory consequences of their decision. The underwriter must not only assess the factual merits of the claim, but also consider the broader impact on the insured's business operations and the insurer's adherence to regulatory principles. Careful judgment is required to ensure that the chosen course of action is both commercially sound and ethically defensible, aligning with the principles of fair dealing and regulatory compliance. The correct approach involves a thorough investigation of the claim's circumstances, a clear understanding of the policy's terms and conditions, and a decision that is consistent with the regulatory framework governing insurance claims handling. This approach prioritizes a fair and objective assessment of liability and damages, ensuring that the insured receives the coverage they are entitled to under the policy, while also protecting the insurer from fraudulent or unwarranted claims. This aligns with the regulatory expectation of prompt, fair, and transparent claims handling, as mandated by the principles of good faith and fair dealing expected of all insurance professionals. An incorrect approach that focuses solely on minimizing immediate payout without a comprehensive investigation risks violating regulatory requirements for claims handling. This could lead to allegations of bad faith, resulting in regulatory penalties, reputational damage, and potential litigation. Another incorrect approach that involves delaying the investigation or decision-making process unnecessarily, even if ultimately leading to a fair outcome, can still be problematic. Such delays can frustrate the insured, potentially disrupt their business, and may be viewed by regulators as a failure to act with due diligence and promptness. A third incorrect approach that relies on assumptions or incomplete information to deny a claim, without proper investigation, is a direct contravention of the duty to investigate claims thoroughly and fairly. This can lead to significant legal and regulatory repercussions. Professionals should adopt a decision-making framework that begins with a comprehensive understanding of the policy and the claim's facts. This involves gathering all relevant evidence, consulting with legal counsel if necessary, and applying a consistent and objective assessment of liability and damages. The decision should then be communicated clearly and promptly to the insured, with a rationale that is consistent with the policy terms and regulatory guidelines. This structured approach ensures that decisions are well supported, defensible, and uphold the highest standards of professional conduct and regulatory compliance. Question 2. The performance metrics show a significant increase in claims where the insured's alleged negligence is disputed due to multiple contributing factors. A commercial general liability adjuster is reviewing a claim where a third party suffered property damage after a fire originated in a warehouse leased by the insured. The claimant alleges the insured's failure to maintain fire suppression systems caused the extensive damage. However, evidence suggests that a faulty electrical appliance, not owned or maintained by the insured, was the initial ignition source, and that a delay in the fire department's response also contributed to the spread of the fire, which approach best navigates the complex causation and negligence principles in this scenario. Option A. Focus on the initial ignition source being an external factor, thereby absolving the insured of responsibility for the fire's origin and subsequent damage. Option B. Conclude that the delay in the fire department's response is the sole proximate cause of the extensive damage, as it allowed the fire to spread significantly. Option C. Investigate whether the insured's failure to maintain the fire suppression systems, if proven negligent, was a substantial and foreseeable factor in the extent of the damage, even if an external factor initiated the fire. Option D. Prioritize the fact that the insured did not own the faulty electrical appliance, thus severing any causal link between the insured's actions and the initial ignition. The correct answer is A. Focus on the initial ignition source being an external factor, thereby absolving the insured of responsibility for the fire's origin and subsequent damage. Explanation. Scenario analysis. This scenario is professionally challenging because it requires distinguishing between mere correlation and legal causation in a complex commercial general liability claim. The adjuster must apply the principles of negligence, specifically the but-for test and proximate cause, to determine if the insured's actions or omissions were the direct and foreseeable cause of the claimant's loss, rather than an intervening event or a pre-existing condition. Misinterpreting causation can lead to incorrect claim denials or excessive payouts, impacting the insurer's financial stability and the insured's trust. Correct approach analysis. The correct approach involves a thorough investigation to establish a direct link between the insured's alleged negligent act or omission and the resulting damage. This requires demonstrating that, but for the insured's conduct, the loss would not have occurred, and that the loss was a foreseeable consequence of that conduct. This aligns with established common law principles of negligence as applied in commercial general liability, ensuring that liability is assigned only when a direct causal connection is proven, thereby upholding fairness and regulatory compliance regarding claims handling. Incorrect approach is analysis, an approach that focuses solely on the timing of events without establishing a direct link between the insured's actions, and the loss fails to meet the but-for test of causation. It mistakes temporal proximity for legal causation, a significant regulatory failure in claims assessment, an approach that attributes the loss entirely to external factors without considering the insured's potential contribution, ignores the principle of proximate cause. If the insured's negligence was a substantial factor in causing the loss, even if other factors were present, they may still be held liable, and failing to assess this is a regulatory oversight. An approach that relies on anecdotal evidence or industry gossip rather than factual investigation and legal principles to determine causation is unprofessional and violates regulatory expectations for objective claims handling. This can lead to arbitrary decisions and potential bad faith claims against the insurer. Professional reasoning. Professionals should adopt a systematic approach to causation analysis. This involves 1. Identifying the alleged negligent act or omission by the insured. 2. Determining the specific loss or damage suffered by the claimant. 3. Applying the but-for test to ascertain if the loss would have occurred without the insured's conduct. 4. Assessing proximate cause to confirm the loss was a foreseeable result of the insured's conduct. 5. Considering any intervening or superseding causes that might break the chain of causation. This structured process ensures that decisions are grounded in legal principles and factual evidence, minimizing the risk of regulatory noncompliance and ethical breaches. Question 3. The review process indicates that a commercial general liability policy issued to a manufacturing firm contains a standard pollution exclusion. The firm is facing a claim alleging that a small, accidental, and sudden release of a chemical cleaning agent from a ruptured pipe onto the factory floor caused minor damage to the flooring and required a one-time cleanup. The cleaning agent is listed as a pollutant in the policy's definitions section, based solely on the regulatory framework and guidelines for the Commercial General Liability Specialist exam. Which of the following approaches to assessing coverage for this claim is most appropriate? Option A. Assume coverage is provided because the release was accidental and the damage was minor, despite the presence of a pollution exclusion. Option B. Deny coverage outright because the policy contains a pollution exclusion and the release substance is defined as a pollutant. Option C. Investigate further to determine if the release was sudden and accidental, and if the specific wording of the pollution exclusion, including any endorsements, applies to this particular type of release and substance, considering the intent of the exclusion. Option D. Rely on general industry knowledge regarding pollution, claims to determine coverage without a detailed review of the specific policy wording and claim facts. The correct answer is B. Deny coverage outright because the policy contains a pollution exclusion and the released substance is defined as a pollutant. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of CGL exclusions, specifically the pollution exclusion, and how it interacts with other policy provisions and the specific facts of a claim. The underwriter must not only identify the relevant exclusion, but also determine if any endorsements or exceptions might apply, and critically, assess whether the claim truly falls within the scope of the exclusion as intended by the policy and regulatory intent. This requires careful judgment to avoid both underinsuring the client and exposing the insurer to undue risk. The correct approach involves a thorough review of the CGL policy, paying close attention to the wording of the pollution exclusion and any relevant endorsements. It requires understanding the intent behind such exclusions, which is generally to exclude coverage for gradual or intentional pollution events, while potentially retaining coverage for sudden and accidental releases. The underwriter must then meticulously analyze the claim facts to ascertain if the release of the substance was gradual or sudden and accidental, and whether it meets the definition of pollutant as defined in the policy. This approach is correct because it adheres to the principle of interpreting insurance contracts in a manner that gives effect to the plain meaning of the words used, while also considering the reasonable expectations of the insured. It aligns with regulatory expectations that insurers apply policy terms consistently and fairly. An incorrect approach would be to automatically deny coverage solely because a substance was released, without further investigation into the nature of the release. This fails to consider potential exceptions or the specific wording of the exclusion, which may not apply to all releases. This approach risks misinterpreting the policy and potentially breaching contractual obligations. Another incorrect approach would be to assume coverage exists simply because the release was accidental, without verifying if the released substance is considered a pollutant under the policy, or if the release falls within the scope of the exclusion's intent. This overlooks the critical definitional elements and the specific limitations imposed by the exclusion. A third incorrect approach would be to rely on external industry standards or general knowledge of pollution claims without consulting the specific policy language and endorsements. Insurance contracts are unique, and their interpretation must be grounded in the precise terms agreed upon by the insurer and the insured. The professional decision-making process for similar situations should involve a structured approach. 1. Identify the relevant policy provision, including all exclusions and endorsements. 2. Understand the precise wording and definitions within those provisions. 3. Gather all available facts pertaining to the claim. 4. Analyze how the claim facts align with or deviate from the policy language, particularly the exclusions. 5. Consider any applicable case law or regulatory guidance that interprets similar exclusion wording within the relevant jurisdiction. 6. Consult with legal counsel or senior underwriting expertise if ambiguity or complexity arises. 7. Document the decision-making process thoroughly, justifying the application or non-application of exclusions based on the policy terms and claim facts. Question 4. The control framework reveals a potential claim arising from alleged damage caused by a faulty component supplied by the insured. The insured's policy includes a product's completed operations hazard exclusion. To accurately assess coverage, what is the most appropriate initial step for the commercial general liability specialist to take? Option A. Prioritize expediting the claim investigation to minimize internal processing time, regardless of the precise policy wording. Option B. Immediately classify the claim as falling outside the product's completed operations exclusion based on the general nature of the damage described. Option C. Accept the insured's initial description of the issue and proceed with the assumption that the claim is outside the scope of the exclusion. Option D. Thoroughly review the policy's definitions section to understand the precise meaning of products and completed operations, and then apply these definitions to the specific facts of the claim, considering the timing of the damage. The correct answer is D. Thoroughly review the policy's definitions section to understand the precise meaning of products and completed operations, and then apply these definitions to the specific facts of the claim, considering the timing of the damage. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of how policy wordings, specifically definitions and conditions, interact with the practical realities of a business's operations and potential claims. The challenge lies in interpreting ambiguous language and applying it to a specific factual matrix, ensuring that the insurer's obligations are accurately assessed without unfairly denying coverage or exposing the insurer to unforeseen liabilities. Careful judgment is required to balance the insurer's need to adhere to policy terms with the insured's reasonable expectations of coverage. The correct approach involves a meticulous review of the policy's definitions section to ascertain the precise meaning of products and completed operations as intended by the policy wording, and in accordance with relevant UK Insurance Law and Financial Conduct Authority (FCA) guidelines. This approach prioritizes a literal and contextual interpretation of the policy terms, seeking to understand the scope of coverage as agreed between the insurer and the insured. It then applies these definitions to the specific facts of the claim, considering the timing of the alleged damage in relation to the policy period and the nature of the product or operation. This aligns with the FCA's principles of treating customers fairly and ensuring that policies are sold and administered in a way that meets the needs of consumers. It also reflects the legal principle of construing insurance policies contra pro fundum, against the party who drafted them, where ambiguity exists, but only after exhausting other methods of interpretation. An incorrect approach that relies solely on the insured's description of the issue without cross-referencing the policy definitions fails to uphold the contractual obligations of the insurance policy. This can lead to either an overassumption of liability or an unfair denial of a valid claim, both of which contravene the FCA's principles of fair treatment and robust claims handling. Another incorrect approach that immediately assumes the claim falls outside the product's completed operations exclusion without a thorough analysis of the definitions and the specific circumstances of the damage demonstrates a failure to conduct due diligence. This can result in an arbitrary decision that may not be supported by the policy wording or regulatory expectations, potentially leading to a dispute and reputational damage. A further incorrect approach that focuses on the insurer's internal claims handling efficiency rather than the policy's substantive terms and conditions risks overlooking critical coverage issues. While efficiency is important, it must not come at the expense of accurate policy interpretation and fair claims assessment, which are paramount under UK regulatory frameworks. Professionals should adopt a systematic decision-making process that begins with a thorough understanding of the policy wording, particularly definitions and exclusions. This should be followed by a detailed factual investigation of the claim. The facts should then be applied to the policy terms, with any ambiguities resolved through established principles of contractual interpretation and regulatory guidance. This ensures that decisions are well-founded, compliant, and fair to all parties. Question 5. Assessment of an insurer's obligation to defend a commercial general liability policyholder when the insured is sued for alleged negligence in a product manufacturing process, and the lawsuit's complaint includes allegations that could be interpreted as relating to both covered occurrences and excluded product recall expenses. Option A. Immediately tender a defense to the insured, subject to a narrowly tailored reservation of rights, specifically outlining the potential exclusion for product recall expenses, while proceeding with a prompt investigation into the factual basis of the allegations. Option B. Delay the decision to defend until the insured provides extensive documentation and expert opinions clarifying the exact nature of the damages sought, even if this process extends beyond the initial review of the complaint and policy. Option C. Deny the defense outright, citing the mention of product recall expenses in the complaint as a clear exclusion, without further investigation into the underlying factual allegations. Option D. Offer a defense only if the insured agrees to a broad reservation of rights that covers any potential exclusion, effectively shifting the burden of proof to the insured to demonstrate coverage. The correct answer is A. Immediately tender a defense to the insured, subject to a narrowly tailored reservation of rights, specifically outlining the potential exclusion for product recall expenses, while proceeding with a prompt investigation into the factual basis of the allegations. Explanation. Scenario analysis. This scenario presents a common yet complex challenge in commercial general liability insurance, determining the insurer's duty to defend when allegations in a lawsuit are ambiguous or potentially fall outside coverage. The professional challenge lies in balancing the insured's right to a defense against the insurer's contractual obligations and financial interests, all while adhering to strict regulatory requirements. Misinterpreting the duty to defend can lead to significant financial penalties, reputational damage, and breach of contract claims against the insurer. Correct approach analysis. The correct approach involves a thorough and objective review of the lawsuit's allegations in light of the commercial general liability policy's terms and conditions. This requires the insurer to look beyond the mere label of the lawsuit and examine the factual basis of the claims. If any of the alleged facts, even if poorly pleaded, could potentially give rise to coverage under the policy, the duty to defend is triggered. This is often referred to as the eight corners rule in many jurisdictions, which dictates that the complaint and the insurance policy are the primary documents for determining the duty to defend. The insurer must act in good faith and provide a defense, even if the allegations are groundless, false, or fraudulent, as long as they are potentially within the scope of coverage. Incorrect approach is analysis. An approach that immediately denies a defense solely because the lawsuit mentions excluded activities without a detailed factual analysis fails to uphold the duty to defend. This is a regulatory failure as it bypasses the requirement to investigate whether the alleged facts themselves, regardless of the lawsuit's framing, could trigger coverage. Prioritizes the insurer's immediate financial interest over the insured's contractual right to a defense. Another incorrect approach is to offer a defense subject to an overly broad reservation of rights that effectively negates the defense obligation. While a reservation of rights is permissible to protect the insurer's interests, it must be specific and not so restrictive as to render the defense illusory. This can be seen as a breach of the duty of good faith and fair dealing, as it undermines the purpose of the defense provision. Finally, delaying the defense decision indefinitely while awaiting further information not readily available through the initial complaint and policy review is also an unacceptable approach. The duty to defend is typically immediate upon receipt of a potentially covered claim. Unreasonable delays can prejudice the insured and constitute a breach of the insurer's obligations. Professional reasoning. Professionals should approach such situations by first identifying the jurisdiction's specific rules governing the duty to defend. This typically involves applying the eight corners rule, or similar principles that mandate a comparison of the complaint's allegations with the policy's insuring agreements and exclusions. The focus must be on the potential for coverage based on the facts alleged, not on the ultimate determination of liability. A good faith assessment requires a diligent review, and if any doubt exists regarding coverage, the duty to defend is generally favored. If a reservation of rights is deemed necessary, it should be narrowly tailored and clearly communicated to the insured. Question 6. Upon reviewing a claim involving a plumbing contractor who manufactured and installed a custom-designed pipe system for a commercial building, it was discovered that a defect in one of the contractor's own manufactured joints caused a significant leak. This leak resulted in water damage to the building's interior walls, flooring, and inventory stored within the affected area. The contractor's commercial general liability policy contains a damage to your product exclusion. Which of the following approaches best reflects the appropriate handling of this claim under the exclusion? Option A. Cover the cost of repairing or replacing the defective pipe joint, and also cover the resulting water damage to the building's walls, flooring, and inventory, as the exclusion applies only to the product itself. Option B. Cover the cost of repairing or replacing the defective pipe joint, but deny coverage for the resulting water damage to the building's walls, flooring, and inventory. Option C. Deny coverage for the water damage to the building's walls, flooring, and inventory, as the contractor's product was the proximate cause of the loss. Option D. Deny coverage for all damage, as the incident originated from a defect in the contractor's manufactured product. The correct answer is D. Deny coverage for all damage, as the incident originated from a defect in the contractor's manufactured product. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the damage to your product exclusion within a commercial general liability policy, specifically in the context of a business that manufactures and installs its own goods. The core difficulty lies in distinguishing between damage to the insured's product itself versus damage to other property caused by a defect in the insured's product. A thorough analysis of the policy wording, relevant case law, and regulatory guidance is essential to avoid misinterpreting the scope of coverage. The correct approach involves carefully examining the cause of the damage and the nature of the property damaged. If the damage is solely to the insured's product, e.g., a faulty valve that leaks and damages only itself, the exclusion likely applies. However, if the defect in the insured's product causes damage to other property, e.g., the faulty valve causes a pipe to burst, damaging the building's plumbing system, then the exclusion may not apply to the damage to the other property, provided the policy does not contain further endorsements that broaden the exclusion. This approach aligns with the general intent of CGL policies to cover liability for damage to third-party property, while excluding coverage for the cost of repairing or replacing the insured's own defective product. Regulatory frameworks typically support this interpretation, emphasizing that the exclusion is intended to prevent the CGL policy from becoming a warranty for the insured's product. An incorrect approach would be to broadly apply the damage to your product exclusion to all damage, regardless of whether it affects the insured's product or other property. This fails to recognize the distinction between damage to the product itself and consequential damage to other property, leading to a denial of coverage that may not be contractually or regulatorily justified. Another incorrect approach would be to ignore the exclusion entirely and assume coverage for all damage, without a detailed analysis of the policy wording and the facts of the claim. This would represent a failure to adhere to the policy contract and could expose the insurer to significant financial risk. A third incorrect approach would be to focus solely on the fact that the insured's product was involved in the incident, without differentiating between damage to the product and damage caused by the product. This overlooks the critical element of what property was actually damaged and the causal link between the defect and that damage. Professionals should approach such situations by first identifying the specific policy language of the damage to your product exclusion. They must then meticulously investigate the facts of the claim, determining precisely what property was damaged and the cause of that damage. This involves distinguishing between damage to the insured's product and damage to other property. Consulting relevant case law and regulatory guidance specific to the jurisdiction is crucial to ensure a consistent and legally sound interpretation of the exclusion. The decision-making process should prioritize a fair and accurate application of the policy terms to the established facts, adhering to principles of good faith and fair dealing. Question 7. Market research demonstrates that clients are increasingly aware of their rights and the avenues for legal recourse. If a commercial general liability specialist receives a formal letter from a client's legal representative alleging professional negligence and threatening legal action, which of the following represents the most appropriate and compliant initial response? Option A. Immediately engage with the client's legal representative to discuss the allegations and explore potential settlement options to resolve the matter quickly. Option B. Forward the letter to the firm's marketing department to assess the potential reputational damage and develop a public relations strategy to mitigate any negative impact. Option C. Acknowledge receipt of the letter internally, initiate a thorough review of the client file and relevant documentation. Notify the firm's professional indemnity insurer and seek immediate advice from legal counsel. Option D. Respond directly to the client, explaining why the allegations are unfounded and providing detailed counterarguments to dissuade them from pursuing legal action. The correct answer is A. Immediately engage with the client's legal representative to discuss the allegations and explore potential settlement options to resolve the matter quickly. Explanation: this scenario is professionally challenging because it involves a direct legal threat against the firm, requiring a nuanced understanding of the firm's obligations and potential liabilities under the Commercial General Liability Specialist regulatory framework. The firm must balance its duty to its clients with its own legal defense and reputational management. Careful judgment is required to ensure all actions are compliant, ethical, and strategically sound, avoiding any missteps that could exacerbate the legal situation or violate regulatory mandates. The correct approach involves a prompt, thorough, and documented internal investigation, coupled with immediate notification to the firm's professional indemnity insurer and legal counsel. This aligns with regulatory requirements for managing potential claims and ensuring the firm has appropriate resources to address legal action. It demonstrates a commitment to transparency, compliance, and responsible risk management, as mandated by the principles of professional conduct for specialists. Prompt notification allows for timely legal advice and the activation of insurance coverage, which is crucial for financial and operational stability. An incorrect approach of ignoring the communication or attempting to resolve it informally, without involving legal counsel and insurers, fails to acknowledge the seriousness of a legal threat. This could lead to regulatory sanctions for failing to manage risk appropriately, potential loss of insurance coverage due to delayed notification, and an inability to mount an effective legal defense. It also risks prejudicing the firm's position and potentially increasing its liability. Another incorrect approach of immediately admitting fault or offering a settlement without proper investigation or legal advice is equally problematic. This can be construed as an admission of liability, which can have severe financial and regulatory consequences. It bypasses the due diligence required to understand the merits of the claim and could lead to unnecessary payouts, damaging the firm's reputation and financial health. Furthermore, such actions might violate specific clauses in the firm's professional indemnity policy regarding claims handling. The professional decision-making process for similar situations should involve a structured response. First, acknowledge receipt of the communication and secure all relevant documentation. Second, immediately consult with the firm's designated legal counsel and professional indemnity insurer. Third, conduct a comprehensive internal review of the matter, gathering all facts and evidence. Fourth, follow the guidance provided by legal counsel and the insurer regarding all subsequent communications and actions. This systematic approach ensures compliance with regulatory obligations, protects the firm's interests, and upholds professional standards. Question 8. Performance analysis shows that a retail store owner, insured under a commercial general liability (CGL) policy, is facing a lawsuit alleging false arrest and unlawful detention of a suspected shoplifter. The insured claims they acted in good faith based on a reasonable suspicion of theft, but the claimant alleges the detention was prolonged and unreasonable, constituting false imprisonment. The underwriter must determine if this claim is covered under the CGL policy. Which of the following approaches best aligns with the regulatory framework and CGL policy principles for handling such a claim? Option A. Refer the claim to the insured's professional liability insurer, as claims of false arrest and detention are generally considered professional errors rather than general business liabilities. Option B. Investigate the claim thoroughly, focusing on the specific wording of the personal and advertising injury insuring agreement and any exclusions related to intentional acts, to ascertain if the insured's actions, while involving detention, were negligent or based on a mistaken belief rather than deliberate malice. Option C. Assume coverage is provided because the CGL policy is designed to protect businesses from a wide range of liabilities, including those arising from customer interactions. Option D. Deny coverage immediately, as claims involving arrest and detention are typically excluded from CGL policies due to the intentional nature of the insured's actions. The correct answer is D. Deny coverage immediately, as claims involving arrest and detention are typically excluded from CGL policies due to the intentional nature of the insured's actions. Explanation. This scenario presents a professional challenge because it requires an insurance underwriter to distinguish between a legitimate business risk covered by a commercial general liability (CGL) policy and a claim that falls outside the scope of coverage due to the intentional nature of the insured's actions. The core difficulty lies in interpreting the policy language, specifically exclusions related to intentional acts, and applying it to the facts of a potential false arrest claim. Careful judgment is needed to avoid both underinsuring the client by denying a valid claim and overinsuring by accepting a claim that clearly violates policy terms. The correct approach involves a thorough review of the CGL policies insuring agreements and exclusions, with a particular focus on the personal and advertising injury coverage and any specific exclusions for personal injury or bodily injury caused by intentional acts. This approach requires understanding that while CGL policies can cover claims arising from false arrest, detention, or imprisonment, this coverage is typically contingent on the insured's actions not being intentionally malicious or criminal. The underwriter must assess whether the insured's actions, as described in the claim, were a direct and intended consequence of their conduct, or if they were a result of negligence or a mistaken belief that their actions were lawful. Regulatory guidance and case law in the relevant jurisdiction would inform this interpretation, emphasizing that coverage is generally intended for accidental harm, not for the direct, intended results of an insured's deliberate wrongdoing. An incorrect approach would be to automatically deny coverage solely because the claim involves arrest or detention, without a detailed examination of the policy wording and the specific circumstances. This fails to recognize that CGL policies often provide coverage for false arrest, detention, or imprisonment when such actions are alleged to have occurred due to the insured's negligence or mistaken belief, rather than deliberate malice. Another incorrect approach would be to assume coverage exists without scrutinizing the personal and advertising injury section and its associated exclusions. This overlooks the critical distinction between negligent acts leading to false arrest and intentional acts designed to cause harm or deprivation of liberty. A further incorrect approach would be to rely on general industry practices rather than the specific terms and conditions of the CGL policy in force. Each policy is a contract, and its specific language dictates coverage, not generalized assumptions about what CGL policies typically cover. The professional decision-making process for similar situations should begin with a comprehensive understanding of the CGL policy's scope of coverage, particularly the personal and advertising injury insuring agreement. This should be followed by a meticulous review of all relevant exclusions, especially those pertaining to intentional acts, willful misconduct, and criminal acts. The underwriter must then gather all available facts surrounding the alleged false arrest, detention, or imprisonment to determine if the insured's actions were intentional and malicious, or if they arose from negligence or a mistaken, but not intentionally wrongful belief. This factual analysis must be applied to the policy language and relevant jurisdictional interpretations to make a coverage determination that is both compliant with the policy contract and ethically sound. Question 9. Implementation of a significant renovation to expand a restaurant's seating capacity and introduce live music presents a critical juncture for a commercial general liability specialist. The insured has informed the broker that the renovation is primarily cosmetic and will not substantially alter the building's footprint. However, the expansion will accommodate an additional 50 patrons, and the live music will be performed nightly. What is the most appropriate course of action for the commercial general liability specialist to ensure adequate coverage for the insured? Option A. Advise the insured that no changes to their insurance are necessary as the building's physical footprint is not significantly altered. Option B. Immediately recommend a substantial increase in the CGL premium based on the increased patron capacity. Option C. Accept the insured's assurance that the changes are minor and will not significantly impact liability and take no further action. Option D. Conduct a thorough review of the renovation plans. Discuss the operational changes with the insured to understand the full scope of new risks and assess the adequacy of the current CGL policy, recommending endorsements or policy adjustments as necessary. The correct answer is D. Conduct a thorough review of the renovation plans. Discuss the operational changes with the insured to understand the full scope of new risks and assess the adequacy of the current CGL policy, recommending endorsements or policy adjustments as necessary. Explanation. Scenario analysis. This scenario presents a common challenge in premises and operations liability, where a seemingly minor alteration to a property can lead to unforeseen liability exposures. The professional challenge lies in accurately assessing the scope of work, identifying potential hazards introduced by the alteration, and ensuring adequate insurance coverage is in place before the work commences. Misjudging the impact of such changes can result in significant uninsured losses for the insured and potential professional liability for the broker. Correct approach analysis. The correct approach involves a thorough review of the proposed renovation plans and a direct discussion with the insured to understand the full scope and potential implications. This proactive engagement allows for the identification of new or increased risks associated with the expanded seating area and the introduction of live music. Specifically, it enables the broker to assess if the existing CGL policy adequately covers potential increases in slip and fall incidents due to increased foot traffic, potential noise complaints, or even liability arising from patron altercations. The broker must then determine if endorsements or a policy review is necessary to ensure coverage aligns with the enhanced operational risks. This aligns with the duty of care owed to the client to provide appropriate insurance advice based on their evolving business operations, as mandated by regulatory guidelines for insurance professionals. Incorrect approach is analysis. One incorrect approach is to simply accept the insured's assurance that the changes are minor and will not significantly impact liability. This fails to uphold the professional duty to investigate and assess risk. It ignores the fundamental principle that changes in operations, even seemingly small ones, can create new or amplified liability exposures that the existing policy may not contemplate. This approach risks leaving the insured underinsured and exposed to significant financial loss, violating ethical obligations and potentially regulatory requirements regarding due diligence. Another incorrect approach is to immediately recommend a significant increase in premium without a detailed analysis of the actual risk increase. While an increase might be warranted, doing so without understanding the specific new exposures, e.g., type of music, seating density, hours of operation, is speculative and may overcharge the client. This demonstrates a lack of professional diligence and could be seen as an attempt to profit from uncertainty rather than providing tailored risk management advice. It fails to meet the standard of providing informed and justified insurance recommendations. A third incorrect approach is to advise the insured that no changes to their policy are necessary because the physical footprint of the building has not drastically changed. This is a critical error, as premises and operations liability is not solely tied to the physical structure, but also to the activities conducted on the premises and the number of people present. The introduction of live music and increased seating directly impacts the nature and intensity of operations, thereby increasing the potential for claims, irrespective of minor structural changes. This demonstrates a fundamental misunderstanding of how CGL policies respond to operational changes. Professional reasoning. Professionals should adopt a systematic approach to managing client changes. This involves 1. Actively listening to and understanding the client's stated changes. 2. Probing for details to uncover the full scope and potential implications of those changes. 3. Assessing the impact of these changes on existing insurance coverage, specifically considering how they might increase or alter liability exposures. 4. Researching and recommending appropriate coverage adjustments, such as endorsements or policy revision, to mitigate identified risks. And 5. Clearly communicating the rationale for any recommended changes and their associated costs to the client. This process ensures that advice is informed, client-centric, and compliant with professional standards and regulatory expectations. Question 10. Which approach would be considered the most prudent and compliant for a policyholder to take when an employee sustains an injury at the workplace that may potentially result in a claim under their commercial general liability policy? Option A. Immediately notify the insurer as soon as the policyholder becomes aware of an injury that could potentially lead to a claim, even if the full extent of the injury or liability is not yet clear. Option B. Inform their insurance broker informally about the injury and await further instructions without directly notifying the insurer. Option C. Wait until a formal demand letter is received or a definitive medical diagnosis confirming significant injury is obtained before reporting the incident to the insurer. Option D. Only report injuries that appear to be minor at the time of the incident, assuming more serious injuries will be reported if they develop. Correct answer is A. Immediately notify the insurer as soon as the policyholder becomes aware of an injury that could potentially lead to a claim, even if the full extent of the injury or liability is not yet clear. Explanation. This scenario presents a professional challenge because the timely reporting of an injury is a critical trigger for a commercial general liability insurer to investigate, assess coverage, and manage potential claims effectively. Delays can prejudice the insurer's ability to investigate the circumstances of the injury, gather evidence, and potentially mitigate damages. Furthermore, policyholders have a contractual obligation to report claims promptly. Navigating the nuances of prompt reporting, especially when the severity of an injury is not immediately apparent, requires careful judgment and adherence to both policy terms and regulatory expectations. The correct approach involves immediately notifying the insurer as soon as the policyholder becomes aware of an injury that could potentially lead to a claim, even if the full extent of the injury or liability is not yet clear. This aligns with the best practice of proactive risk management and fulfills the policyholder's duty to report. Regulatory frameworks, such as those governing insurance claims handling, emphasize the importance of timely notification to ensure fair and efficient claims processing. Ethically, this approach demonstrates good faith and cooperation with the insurer, fostering a transparent relationship. An incorrect approach involves waiting for a formal demand letter or a definitive diagnosis before reporting the incident. This failure to report promptly can be seen as a breach of the policy conditions and may give the insurer grounds to deny coverage due to late notice, especially if the delay has prejudiced their investigation. Regulatory bodies often have guidelines or expectations regarding the timeframe for reporting claims, and significant delays can lead to regulatory scrutiny and potential penalties for insurers who do not manage claims appropriately. Another incorrect approach is to only report injuries that appear to be minor at the time of the incident. This is problematic because injuries can worsen over time, and what initially seems minor can develop into a significant claim. Failing to report such incidents upfront means the insurer is not given the opportunity to investigate while evidence is fresh and witnesses are available, potentially leading to coverage disputes. A further incorrect approach is to rely on informal communication with an insurance broker without formally notifying the insurer. While brokers are valuable intermediaries, the policyholder's contractual obligation is typically to notify the insurer directly or through an authorized channel as specified in the policy. Informal communication may not constitute official notice and could be overlooked or misinterpreted, leading to a missed reporting deadline. Professionals should adopt a decision-making framework that prioritizes prompt and clear communication with their insurer. This involves understanding the reporting requirements outlined in the Commercial General Liability Policy, erring on the side of caution by reporting any incident that could reasonably lead to a claim, and documenting all communications with the insurer. When in doubt about whether an incident warrants reporting, it is always best practice to report it. Question 11. The analysis reveals that a commercial client has suffered significant business interruption and financial losses due to a sophisticated cyber attack that compromised their customer database, rendering their online sales platform inoperable for several weeks. The client is seeking coverage under their Commercial General Liability (CGL) policy for these losses, arguing that the inability to access and utilize their critical customer data constitutes damage to their business operations. As a CGL specialist, how should you proceed in evaluating this claim, considering the policy's definitions of bodily injury and property damage? Option A. Deny coverage, as the policy's definition of property damage typically requires physical injury to or destruction of tangible property, and the loss of access to intangible data does not meet this threshold. Option B. Grant coverage, as the business interruption and financial losses are a direct consequence of the inability to use essential business assets, which can be broadly interpreted as damage to the business. Option C. Seek clarification from the client on the nature of the data compromised, assuming that if the data was stored on physical media that was damaged, coverage might be applicable under a broad interpretation of property damage. Option D. Recommend purchasing a cyber liability endorsement, as standard CGL policies are not designed to cover losses arising from cyber attacks and data breaches. The correct answer is A. Deny coverage, as the policy's definition of property damage typically requires physical injury to or destruction of tangible property, and the loss of access to intangible data does not meet this threshold. Explanation. Scenario analysis. This scenario presents a professional challenge due to the ambiguity of whether a business interruption claim, stemming from a data breach that rendered a client's systems inoperable, constitutes property damage under a Commercial General Liability (CGL) policy. The core difficulty lies in interpreting the policy's definitions of property damage, when the damage is to intangible data and the resulting loss is business interruption, not physical destruction. A CGL specialist must navigate the precise wording of the policy and relevant case law to determine coverage, balancing the insurer's obligation to indemnify with the need to avoid unwarranted payouts. Correct approach analysis. The correct approach involves a meticulous review of the CGL policy's definition of property damage and any applicable endorsements or exclusions. This definition typically requires physical injury to or destruction of tangible property. If the policy's definition is narrow and does not explicitly include intangible property or consequential business interruption losses arising from data loss, then coverage would likely be denied. This approach is correct because it adheres strictly to the contractual language of the insurance policy, which is the primary determinant of coverage. The specialist must apply the established legal interpretation of property damage, as understood within the relevant jurisdiction's case law, which generally requires a physical element. Incorrect approach is analysis, an approach that assumes coverage based solely on the client's significant financial loss and business interruption, without first verifying if the policy's definition of property damage encompasses intangible data loss or consequential business interruption, is incorrect. This fails to respect the contractual limitations of the policy and could lead to an improper claim payment. An approach that relies on industry custom or general understandings of business losses, rather than the specific policy wording and legal precedent, is also incorrect. Insurance policies are contracts of adhesion, and their terms are paramount. Relying on external factors without grounding in the policy language is a deviation from sound underwriting and claims handling principles. An approach that interprets damage broadly to include any disruption or loss of function, regardless of whether it meets the policy's definition of property damage, is incorrect. This misinterprets the legal and contractual meaning of the term, potentially exposing the insurer to liabilities not contemplated or priced for within the policy. Professional reasoning. Professionals should adopt a systematic approach. 1. Identify the core claim, business interruption due to data breach. 2. Locate relevant policy provisions, specifically the definitions of bodily injury and property damage. 3. Analyze the definition of property damage. Does it require physical injury to or destruction of tangible property? Does it explicitly include or exclude intangible property? 4. Research relevant case law. Understand how courts in the applicable jurisdiction have interpreted property damage in similar contexts, particularly concerning data and intangible assets. 5. Apply policy language and case law to the facts. Determine if the client's loss meets the policy's definition of property damage. 6. Consider exclusions and endorsements. Review these for any clauses that might further clarify or limit coverage. 7. Formulate a coverage position based on this rigorous analysis. Question 12. The monitoring system demonstrates that a commercial general liability policy's declarations page has been issued for a new client. What is the most critical step a commercial general liability specialist must take to ensure the policy accurately reflects the client's risk profile and contractual obligations? Option A. Treat the declarations page as a standardized document and only verify the named insured and policy number, as other details are typically pre-filled. Option B. Conduct a thorough review of the declarations page, cross-referencing all details with the policy wording, endorsements, and the client's specific business operations to confirm accuracy and completeness. Option C. Focus primarily on the total premium paid, assuming that a higher premium indicates a more comprehensive and suitable level of coverage. Option D. Accept the broker's summary of the policy's coverage as sufficient, assuming the broker has accurately conveyed the key terms to the client. The correct answer is B. Conduct a thorough review of the declarations page, cross-referencing all details with the policy wording, endorsements, and the client's specific business operations to confirm accuracy and completeness. Explanation. This scenario is professionally challenging because it requires a specialist to interpret a critical document, the declarations page, which forms the basis of the insurance contract. Misinterpreting this page can lead to significant financial and legal repercussions for both the insured and the insurer. The specialist must exercise careful judgment to ensure all parties understand their coverage accurately, preventing potential disputes and ensuring compliance with regulatory requirements. The correct approach involves meticulously reviewing the declarations page for accuracy and completeness, cross-referencing it with the policy wording, and the insured's specific business operations. This ensures that the coverage described aligns with the risks undertaken and that all endorsements and exclusions are clearly understood. This approach is correct because it upholds the principle of utmost good faith, a cornerstone of insurance law and regulation. It ensures transparency and clarity, preventing misrepresentation or non-disclosure, and aligns with the regulatory expectation that insurance contracts are clear and understandable to the policyholder. An incorrect approach would be to solely rely on the broker's summary without independent verification. This is professionally unacceptable because it abdicates the specialist's responsibility to ensure the accuracy of the contractual document. It fails to uphold the duty of care owed to the insured and could lead to coverage gaps or misunderstandings, potentially violating regulatory provisions that mandate clear communication of policy terms. Another incorrect approach would be to focus only on the premium amount, assuming that a higher premium automatically equates to comprehensive coverage. This is flawed because the premium is a reflection of risk and coverage limits, but not a guarantee of suitability or completeness. It ignores the critical details of what is actually insured, the limits, deductibles, and any specific endorsements or exclusions that significantly shape the coverage. This approach risks overlooking crucial policy features and could lead to a false sense of security for the insured, failing to meet regulatory standards for policy clarity and adequacy. A further incorrect approach would be to assume that the declarations page is a standard template and requires no specific attention to detail for each policy. This is a dangerous assumption. Each declarations page is specific to the policyholder and their unique risks. Failing to scrutinize it for individual nuances, such as specific named insureds, locations, or scheduled property, can lead to significant errors in coverage interpretation and application, contravening regulatory expectations for accurate policy administration. The professional decision-making process for similar situations should involve a systematic review of all policy documents, with particular emphasis on the declarations page. This includes verifying all factual information, understanding the scope of coverage, identifying any endorsements or exclusions that modify standard terms, and ensuring that the policy accurately reflects the insured's stated needs and the insurer's underwriting. When in doubt, seeking clarification from the underwriter or broker and communicating any discrepancies clearly to the insured is paramount. This methodical and diligent approach ensures compliance, upholds ethical obligations, and protects the interests of all parties involved. Question 13. The risk matrix shows a significant potential for claims arising from the insured's use of specialized industrial cleaning solvents at client premises, particularly concerning potential environmental damage and respiratory issues for building occupants. The insured operates a commercial cleaning business that services office buildings and light industrial facilities. The CGL policy in question contains a standard exclusion for pollution, but also a specific exclusion for work performed at heights exceeding 50 feet. The insured's primary operations involve ground-level cleaning and interior maintenance, but they occasionally subcontract work involving window cleaning at heights up to 75 feet. Which of the following approaches best addresses the potential coverage gaps and regulatory compliance for this scenario? Option A. Assume the CGL policy will automatically cover any environmental damage or respiratory issues, as these are common risks for a cleaning business, and that the work at heights exclusion is a standard clause that does not require specific consideration unless explicitly brought to the underwriter's attention. Option B. Conduct a detailed review of the specific wording and applicability of the pollution exclusion to the types of solvents used and the potential environmental impact, and assess whether the work at heights exclusion is triggered by the subcontracted work, potentially recommending endorsements or specific policy limitations to address these identified risks. Option C. Rely solely on the general pollution exclusion to deny any claims related to solvent use, and assume the work at heights exclusion is irrelevant as the insured's primary operations are ground level. Option D. Advise the insured that the general pollution exclusion will apply to all solvent-related claims, and that the work at heights exclusion will also apply, effectively leaving them uninsured for these specific risks without further action. The correct answer is C. Rely solely on the general pollution exclusion to deny any claims related to solvent use, and assume the work at heights exclusion is irrelevant as the insured's primary operations are ground level. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of how exclusions in a commercial general liability (CGL) policy interact with specific business operations and potential claims. The underwriter must not only identify relevant exclusions, but also assess their applicability based on the precise nature of the insured's activities and the potential for claims arising from those activities. Misinterpreting or misapplying exclusions can lead to either inadequate coverage for the insured or the insurer taking on risks they did not intend to cover, both of which have significant financial and reputational consequences. The correct approach involves a thorough review of the insured's operations and a precise matching of those operations against the specific wording of the CGL policy's exclusions. This includes understanding the scope and intent of exclusions related to specific accidents, products, work, or locations. For instance, If the insured is a contractor performing specialized welding in a high-rise building, the underwriter must carefully examine exclusions related to completed operations, pollution, or work performed at specific heights or in hazardous environments. The regulatory framework for CGL insurance mandates that policies clearly define their coverage and limitations. Therefore, a correct assessment ensures that the policy accurately reflects the risks undertaken and complies with regulatory requirements for clarity and fairness to the insured. This approach prioritizes accurate risk assessment and adherence to policy terms and conditions as defined by the relevant regulatory bodies governing insurance contracts. An incorrect approach would be to apply a broad, generalized exclusion without considering the specific context of the insured's operations. For example, assuming a standard completed operations exclusion automatically applies to all construction work without analyzing the specific type of work, the duration of the project, and the potential for latent defects would be a failure. This overlooks the detailed definitions and limitations often found within exclusion clauses, which are designed to be specific. Another incorrect approach would be to ignore the potential for claims arising from a specific location, such as a leased retail space with unique environmental risks, simply because the general business operations appear standard. This fails to acknowledge that location-specific hazards can trigger certain exclusions or necessitate endorsements. Ethically and regulatorily, such broad-stroke applications can lead to claims being unfairly denied, violating principles of good faith and fair dealing, and potentially breaching regulatory requirements for policy interpretation and claims handling. Professionals should adopt a decision-making process that begins with a comprehensive understanding of the insured's business activities, including their products, services, work processes, and operating locations. This understanding should then be systematically compared against the specific language of the CGL policy's exclusions. When ambiguity exists, or when the application of an exclusion is not straightforward, the professional should consult policy wording, relevant case law, if applicable within the jurisdiction, and potentially seek guidance from legal counsel or senior underwriters. The ultimate goal is to ensure that the policy's exclusions are applied consistently with their intended purpose and within the bounds of regulatory requirements, providing fair and adequate coverage while managing the insurer's risk exposure. Question 14. The evaluation methodology shows that when assessing claims for medical expenses under a commercial general liability policy, particularly concerning coverage B personal and advertising injury liability, and the medical payments to others provision, a specialist must differentiate between immediate, necessary medical treatment arising from an accident and broader, long-term care costs. Which of the following approaches most accurately reflects the regulatory framework for determining the extent of covered medical expenses in such a scenario? Option A. Deny all medical expense claims if the claimant has any other form of health insurance, as the CGL policy is intended to be a secondary source of coverage. Option B. Cover all medical expenses, including ongoing rehabilitation and future treatment, if the claimant can demonstrate a connection to the insured's operations, even if the expenses extend beyond the policy's stated limits or timeframes. Option C. Cover only those medical expenses that are directly and proximately caused by a covered bodily injury resulting from an occurrence and are incurred within 1 year of the accident, as stipulated by the medical payments to others coverage. Option D. Cover all medical expenses incurred by an injured party on the insured's premises, regardless of the cause of injury or the time frame of treatment, as a demonstration of good faith. The correct answer is D. Cover all medical expenses incurred by an injured party on the insured's premises, regardless of the cause of injury or the time frame of treatment, as a demonstration of good faith. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of what constitutes medical expenses under a commercial general liability (CGL) policy, specifically concerning the coverage B personal and advertising injury liability, and its interaction with the medical payments to others coverage. The core difficulty lies in distinguishing between expenses directly arising from bodily injury covered under the CGL policy versus those that might be considered incidental or related to other covered offenses. A CGL specialist must apply the policy's definitions and exclusions precisely, considering the intent of the coverage. The correct approach involves a thorough review of the policy's definitions of bodily injury and medical expenses, alongside the specific conditions and exclusions related to coverage B and the medical payments coverage. This approach correctly identifies that medical expenses are typically covered when they are a direct and proximate result of bodily injury caused by an occurrence, as defined by the policy. The policy's intent for medical payments coverage is to provide a limited no-fault benefit for immediate medical treatment following an accident on the insured's premises or arising from the insured's operations, regardless of fault. Therefore, expenses for necessary medical, surgical, ambulance, hospital, professional nursing, and funeral services are generally included if incurred within 1 year of the accident. The specialist must ensure the claimed expenses meet these criteria and are not excluded by other policy provisions. An incorrect approach would be to broadly interpret medical expenses to include any cost associated with an injury, even if it doesn't directly stem from the covered bodily injury or falls outside the scope of the medical payments coverage. For instance, including costs for ongoing rehabilitation or long-term care that extend beyond the policy's stipulated 1-year period or are not directly linked to the initial accident would be a regulatory failure. Another incorrect approach is to assume that any injury sustained on the insured's premises automatically triggers full medical expense coverage without verifying if the injury itself is a result of an occurrence as defined by the policy. This ignores the fundamental requirement of a covered cause of loss. A further incorrect approach would be to deny coverage for immediate, necessary medical treatment simply because the claimant might have other insurance or because the insured's liability is not yet established, as the medical payments coverage is designed to be a prompt, no-fault benefit. Professionals should employ a decision-making framework that prioritizes policy interpretation and factual investigation. This involves 1. Identifying the specific coverage at issue and the relevant policy definitions and exclusions. 2. Ascertaining the facts of the incident, including the cause of the injury and the nature of the expenses incurred. 3. Applying the policy language to the facts, determining if the expenses are a direct result of a covered bodily injury and fall within the scope of the medical payments coverage. 4. Consulting relevant case law or regulatory guidance if ambiguity exists. 5. Communicating the coverage decision clearly and transparently to all parties. Question 15. The audit findings indicate that a client, a small e-commerce business specializing in artisanal soaps, is facing a lawsuit alleging that their online advertisements for a new Lavender Dream soap line misappropriated the advertising ideas and distinctive marketing style of a competitor. The competitor claims their unique visual presentation and slogan, developed over several years, were copied by the insured, leading to a loss of sales. The commercial general liability policy in question contains a personal and advertising injury coverage section, but it is subject to an exclusion for misappropriation of advertising ideas or style or the imitation of advertising ideas or style. Based on these findings, what is the most appropriate initial step for the underwriter to take in assessing potential coverage for this claim? Option A. Immediately deny coverage based on the presence of the misappropriation of advertising ideas or style exclusion, as the claim directly mentions advertising ideas and style. Option B. Advise the insured that their policy does not cover any claims related to advertising, regardless of the specific nature of the allegations, as all advertising activities are inherently excluded. Option C. Determine if the insured's alleged actions constitute the misappropriation of a unique advertising concept or creative marketing approach, distinct from the mere imitation of product packaging or general marketing themes, and if this misappropriation is the direct cause of the alleged injury. Option D. Focus on whether the competitor can prove actual financial damages resulting from the alleged imitation, as the extent of financial loss is the primary determinant of coverage. The correct answer is C. Determine if the insured's alleged actions constitute the misappropriation of a unique advertising concept or creative marketing approach, distinct from the mere imitation of product packaging or general marketing themes, and if this misappropriation is the direct cause of the alleged injury. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the personal and advertising injury exclusions within a commercial general liability policy, specifically in relation to the definition of advertising injury and the concept of misappropriation of advertising ideas. The auditor's concern highlights a potential gap in coverage that could lead to significant financial exposure for the insured if not properly addressed. The challenge lies in interpreting the policy language against the specific facts of the insured's business activities, requiring careful judgment to determine if the exclusion applies or if an exception might be triggered. The correct approach involves a thorough review of the policy's personal and advertising injury coverage grant and its associated exclusions, particularly the exclusion for misappropriation of advertising ideas or style, or the imitation of advertising ideas or style. This approach necessitates understanding the specific nature of the insured's alleged infringement. If the insured's actions involve the unauthorized use of another party's unique advertising concepts, slogans, or creative materials that are integral to their marketing strategy, and this use is not merely incidental to the sale of goods or services, then the exclusion is likely to apply. The justification for this approach is rooted in the principle of adhering strictly to the policy's contractual terms. The exclusion is designed to prevent coverage for claims arising from the theft of intellectual property related to marketing, rather than the direct sale of infringing products. An incorrect approach would be to assume coverage simply because the claim involves advertising. This fails to acknowledge the specific wording of the exclusion. Another incorrect approach would be to broadly interpret advertising injury to encompass any harm related to marketing activities without considering the specific exclusions. This ignores the contractual limitations of the policy. A further incorrect approach would be to dismiss the auditor's concern without a detailed analysis of the policy language and the insured's activities, potentially leading to an underestimation of risk and an uninsured loss for the insured. These incorrect approaches fail to uphold the duty of care owed to the insured and to accurately assess the policy's coverage. The professional decision-making process for similar situations should involve 1. Clearly identifying the specific policy provisions in question, coverage grant and exclusions. 2. Gathering all relevant facts about the insured's business and the nature of the alleged claim. 3. Analyzing the facts against the precise wording of the policy, paying close attention to definitions and exclusions. 4. Consulting relevant case law or industry guidance if the policy language is ambiguous or the situation is complex. 5. Documenting the analysis and the rationale for the coverage determination. Question 16. Consider a scenario where a commercial general liability policy contains an aircraft, auto, or watercraft exclusion endorsement. The insured, a landscaping company, is sued for property damage that occurred when a client's personal pleasure boat, which the insured was temporarily operating to move it from a dock to a nearby mooring, struck and damaged a pier. The policy exclusion states it does not apply to bodily injury or property damage arising out of the ownership, maintenance, or use of watercraft. Based on the provided policy wording and the facts, what is the most appropriate regulatory and ethically sound approach for the underwriter to take regarding coverage for this claim? Option A. Grant coverage, as the primary business of the insured is landscaping, not operating watercraft. Option B. Investigate further to determine if the damage was caused by faulty equipment used in the landscaping business that was being transported on the boat. Option C. Offer a partial settlement, acknowledging the insured's business focus but also the involvement of a watercraft. Option D. Deny coverage based on the watercraft exclusion, as the damage arose from the operation of a watercraft. The correct answer is D. Deny coverage based on the watercraft exclusion, as the damage arose from the operation of a watercraft. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of insurance policy exclusions, specifically concerning the use of watercraft. The underwriter must accurately interpret the policy language and apply it to the specific facts of the claim, ensuring that coverage is neither unfairly denied nor inappropriately granted. This requires careful judgment to balance the insurer's obligation to uphold policy terms with the insured's expectation of coverage. The correct approach involves a thorough review of the commercial general liability (CGL) policy's aircraft, auto, or watercraft exclusion endorsement. This approach correctly identifies that the exclusion typically applies to bodily injury or property damage arising out of the ownership, maintenance, or use of watercraft. The key is to determine if the insured's actions, as described, fall within the scope of this exclusion, as defined by the policy wording and relevant case law within the specified jurisdiction. If the policy clearly excludes damage arising from the operation of a pleasure boat, and the insured was operating such a boat at the time of the incident, then denying coverage based on the exclusion is the appropriate regulatory and ethical action. This aligns with the principle of adhering to the contract of insurance as written. An incorrect approach would be to grant coverage without a detailed examination of the watercraft exclusion. This fails to uphold the contractual terms of the policy and could lead to financial losses for the insurer that were not contemplated or priced for. It also sets a dangerous precedent for future claims. Another incorrect approach would be to deny coverage solely because a watercraft was involved, without considering the specific wording of the exclusion and whether the insured's use of the watercraft directly caused the damage. Some exclusions may have specific definitions or limitations that could still allow for coverage depending on the circumstances. For example, if the damage was caused by a faulty product installed on the boat rather than the operation of the boat itself, the exclusion might not apply. Professionals should approach such situations by first meticulously reviewing the policy language, paying close attention to definitions, and the precise wording of any exclusions. They should then gather all relevant facts about the incident. Next, they must research any applicable case law within the jurisdiction that interprets similar exclusion clauses. Finally, they should make a coverage decision based on a comprehensive analysis of the policy terms, the facts, and the legal precedents, documenting their reasoning thoroughly. Question 17. The performance metrics show an increase in claims related to construction defects where the insured's work has allegedly caused damage to other completed portions of the project. A contractor, insured under a commercial general liability policy, completed electrical wiring in a new commercial building. Subsequently, a fire occurred, damaging the electrical wiring installed by the insured, as well as adjacent structural components and finishes that were already completed by other trades. The insured argues that the fire was a direct result of a defect in their wiring. Which of the following approaches best reflects the proper application of the damage to your work exclusion in this scenario? Option A. Cover the cost of repairing or replacing the defective electrical wiring, as well as the damage to the adjacent structural components and finishes, as the latter constitutes damage to property of others or other property not part of the insured's specific work. Option B. Deny coverage entirely, as the damage originated from the insured's work, which is explicitly excluded under the damage to your work provision. Option C. Offer a partial settlement based on the estimated percentage of the insured's work that was defective, regardless of the extent of damage to other property. Option D. Cover the cost of repairing or replacing the defective electrical wiring installed by the insured, but deny coverage for the damage to the adjacent structural components and finishes. The correct answer is B. Deny coverage entirely, as the damage originated from the insured's work, which is explicitly excluded under the damage to your work provision. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the damage to your work exclusion within a commercial general liability policy, specifically in the context of construction projects where multiple parties and their work are interconnected. The core difficulty lies in distinguishing between damage to the insured's own work that is excluded and damage to other property, including other parts of the insured's work not yet completed or integrated, that may be covered. Misinterpreting this exclusion can lead to significant financial disputes and reputational damage for the insurer. Careful judgment is required to apply the policy terms accurately to the specific facts of the claim. The correct approach involves a thorough examination of the policy wording, particularly the damage to your work exclusion, and its application to the specific facts of the claim. This requires determining whether the damage claimed is to the work performed by the insured, and if so, whether the damage is to that specific portion of the work or to other property. The exclusion typically applies only to the cost of repairing or replacing the insured's own defective work, not to damage caused by that defective work to other parts of the project or to property of others. This approach aligns with the principle of indemnity, which aims to restore the insured to their pre-loss position, and the fundamental purpose of CGL insurance, which is to cover liability for damage to property of others and bodily injury. Regulatory frameworks generally expect insurers to interpret policy language reasonably, and in a manner that upholds the reasonable expectations of the policyholder. An incorrect approach would be to broadly deny coverage solely because the damage originated from the insured's work. This fails to recognize that the exclusion is narrowly tailored and does not preclude coverage for consequential damage to other property. Another incorrect approach is to assume that any damage occurring during the insured's work is automatically excluded, without a detailed factual investigation into the cause and extent of the damage. This overlooks the distinction between the insured's work itself and other property that may have been damaged as a result of a defect in the insured's work. Furthermore, an incorrect approach would be to rely on internal guidelines or past practices that are not consistent with the explicit policy language and relevant case law interpreting such exclusions. Such actions could be seen as a failure to act in good faith and could violate regulatory requirements for fair claims handling. The professional decision-making process for similar situations should involve 1. A comprehensive review of the CGL policy, paying close attention to the damage to your work exclusion and any relevant endorsements. 2. A detailed factual investigation to understand the cause of the damage, the scope of the damage, and precisely which property was damaged. 3. An analysis of how the facts align with the policy language, specifically distinguishing between damage to the insured's work and damage to other property. 4. Consideration of any applicable case, law, or regulatory guidance that interprets similar exclusions. 5. Clear and transparent communication with the policyholder regarding the coverage position, supported by the policy terms and factual findings. Question 18. Benchmark analysis indicates that a commercial general liability policy renewal presents a heightened risk profile due to an increase in the insured's operational complexity and a recent uptick in industry-wide claims for similar businesses. When considering the decision to not renew the policy, which of the following approaches best aligns with regulatory compliance and professional underwriting standards? Option A. Non-renew the policy immediately upon identifying the increased risk, without further investigation, to protect the insurer from potential future losses. Option B. Non-renew the policy based on the general industry trend alone, without a specific analysis of the individual insured circumstances, to maintain a consistent underwriting stance. Option C. Offer a renewal with significantly increased premiums and reduced coverage limits without a clear explanation, hoping the insured will decline the renewal. Option D. Conduct a comprehensive risk assessment, including a detailed review of the insured's claims history, operational changes, and adherence to policy conditions. And if non-renewal is deemed necessary, provide timely and legally compliant notification to the insured with clear justification. The correct answer is A. Non-renew the policy immediately upon identifying the increased risk, without further investigation, to protect the insurer from potential future losses. Explanation. Scenario analysis. This scenario is professionally challenging because the decision to not renew a commercial general liability policy involves significant risk assessment and potential impact on the insured's business operations. The underwriter must balance the insurer's risk appetite and profitability with the insured's need for continuous coverage. Failure to properly assess the risks associated with non-renewal can lead to regulatory scrutiny, financial losses for the insurer, and reputational damage. The professional challenge lies in making a data-driven, compliant, and ethically sound decision that considers all relevant factors. Correct approach analysis. The correct approach involves a thorough review of the insured's claims history, risk profile, and adherence to policy conditions. This includes evaluating any emerging risks or changes in the insured's operations that may have increased their exposure. The underwriter must also consider the insurer's underwriting guidelines and appetite for the specific class of business. If the decision is made not to renew, it is crucial to provide clear, timely, and legally compliant notification to the insured, outlining the reasons for non-renewal. This approach aligns with regulatory requirements for fair dealing and transparency, ensuring the insured has adequate time to secure alternative coverage and mitigating potential bad faith claims. It also upholds the insurer's responsibility to manage its underwriting portfolio effectively. Incorrect approaches analysis. One incorrect approach is to non-renew solely based on a recent increase in the insured's premium, without a detailed analysis of the underlying risk factors contributing to that increase. This fails to address the root cause of the premium change, and may lead to the insurer losing a potentially profitable account if the risk is manageable. It also lacks the transparency and detailed justification required by regulatory bodies overseeing fair insurance practices. Another incorrect approach is to non-renew without providing adequate notice to the insured. This can leave the insured uninsured, potentially exposing them to significant financial and legal liabilities. Regulatory frameworks typically mandate specific notice periods for non-renewal to allow the insured sufficient time to find replacement coverage, and failing to adhere to these requirements can result in penalties and legal action. A third incorrect approach is to non-renew based on subjective biases or without documented underwriting rationale. This is ethically unsound and can lead to allegations of discrimination. Regulatory bodies expect underwriting decisions to be based on objective criteria and consistent application of underwriting guidelines, not on arbitrary or discriminatory factors. Professional reasoning. Professionals should approach non-renewal decisions by first establishing clear underwriting criteria and risk assessment protocols. This involves a systematic evaluation of the insured's risk profile, claims experience, and compliance with policy terms. When considering non-renewal, the decision-making process should be documented, transparent, and aligned with regulatory requirements for notice and justification. Professionals must also be aware of any specific industry codes of conduct or ethical guidelines that govern insurer-insured relationships during the renewal process. A proactive approach, including open communication with the insured about potential concerns prior to the renewal date, can often mitigate the need for non-renewal and foster stronger business relationships. Question 19. Process analysis reveals that a commercial general liability policy contains a standard war exclusion clause. The insured's operations in a foreign country have been significantly disrupted by widespread, organized armed conflict between government forces and a recognized rebel group, resulting in damage to the insured's property and business interruption. The insured submits a claim for these losses. Which of the following approaches best aligns with regulatory requirements for handling such a claim under the war exclusion? Option A. Investigate the specific wording of the war exclusion clause, including definitions of war, invasion, rebellion, and insurrection, and assess whether the events directly meet these defined terms and cause the loss, consulting relevant legal and regulatory interpretations if ambiguity exists. Option B. Advise the insured that all losses related to political instability are excluded under the war exclusion, regardless of the specific nature of the events. Option C. Offer to settle the claim for a reduced amount, acknowledging the disruption, but assuming the exclusion applies broadly to any significant civil unrest. Option D. Deny the claim immediately, as widespread armed conflict clearly constitutes war and is excluded. The correct answer is D. Deny the claim immediately, as widespread armed conflict clearly constitutes war and is excluded. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the war exclusion clause within the context of evolving geopolitical events and their potential impact on commercial operations. Specialists must not only interpret the policy wording, but also apply it to a situation where the definition of war and hostile acts can be ambiguous and subject to interpretation by various authorities. The core challenge lies in distinguishing between acts of war and other forms of civil unrest or terrorism, which may or may not be covered by the policy, depending on the precise wording of the exclusion and relevant case law or regulatory guidance. The correct approach involves a thorough review of the specific wording of the war exclusion clause in the commercial general liability policy. This includes examining definitions of war, invasion, act of foreign enemy, civil war, rebellion, revolution, insurrection, or military power. The specialist must then assess whether the events in the insured's operating territory clearly fall within these defined terms. If the events are ambiguous or fall into a gray area, the specialist should consult relevant policy endorsements that might modify or clarify the war exclusion, and any applicable regulatory guidance or precedent that interprets such clauses in similar contexts. The ultimate goal is to determine if the loss is directly caused by an event that the policy explicitly excludes. This approach aligns with the regulatory requirement to act with due diligence and skill, ensuring that policy interpretations are grounded in the contract and applicable legal/regulatory frameworks. An incorrect approach would be to immediately deny coverage based on a superficial understanding of the term war, without a detailed analysis of the policy's specific exclusion wording. This fails to acknowledge the potential for ambiguity and the need for precise contractual interpretation. Another incorrect approach is to assume that any act of violence or political instability automatically triggers the war exclusion, without considering the specific definitions and causation requirements within the policy. This overlooks the distinction between acts of war and other perils that might be covered. Furthermore, relying solely on media reports or general public perception of the events, rather than the policy's contractual language and relevant legal interpretations, constitutes a failure to adhere to professional standards and regulatory expectations for objective assessment. Professionals should adopt a systematic decision-making process. This begins with a comprehensive review of the insurance policy, paying close attention to the specific language of the war exclusion and any related definitions or endorsements. Next, gather all relevant facts about the incident, focusing on the nature of the events, their cause, and their direct impact on the insured's operations. Compare these facts against the policy's exclusion language, seeking to understand if the events meet the criteria for exclusion. If ambiguity exists, research relevant case law, regulatory interpretations, and industry best practices for interpreting war exclusions. Consult with legal counsel or subject matter experts if necessary. Document all steps taken, the evidence reviewed, and the rationale for the coverage decision. Question 20. Process analysis reveals that a commercial general liability policy contains an exclusion for misappropriation of advertising ideas or style. A claimant alleges that the insured company copied their marketing campaign's unique visual aesthetic and slogan, leading to a loss of market share. What is the most appropriate approach for the commercial general liability specialist to evaluate coverage for this claim? Option A. Rely solely on the claimant's assertion that their advertising idea was misappropriated without further factual investigation. Option B. Grant coverage automatically because the claim involves advertising and the exclusion is too ambiguous to apply. Option C. Deny coverage immediately, as any claim involving competitive advertising practices falls under the exclusion. Option D. Investigate whether the claimant's alleged injury stems from the insured's adoption of a truly novel and proprietary advertising concept or style, as defined by the exclusion's specific wording and relevant case law. The correct answer is C. Deny coverage immediately, as any claim involving competitive advertising practices falls under the exclusion. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of advertising injury exclusions, specifically the misappropriation of advertising ideas or style exclusion. Determining whether a claim falls within this exclusion often hinges on the specific facts and the interpretation of policy language, which can be subjective. A specialist must balance the insurer's obligation to defend and indemnify with the need to apply policy terms accurately to prevent unwarranted payouts or coverage denials. The difficulty lies in distinguishing between a claim that genuinely alleges the theft of a unique advertising concept versus one that merely involves a dispute over marketing methods or content that doesn't meet the exclusion's threshold. Correct approach analysis. The correct approach involves a thorough review of the claimant's allegations against the precise wording of the misappropriation of advertising ideas or style exclusion. This approach is best professional practice because it adheres strictly to the policy contract and relevant case law interpreting such exclusions. The specialist must ascertain if the claimant's alleged injury stems from the defendant's adoption of a truly novel and proprietary advertising concept or style, rather than a more general competitive practice. This requires careful factual investigation and legal analysis to determine if the core of the claim is about the theft of an idea or style that is distinct and identifiable, as opposed to a broader claim of unfair competition or infringement of less specific marketing materials. This meticulous examination ensures that the exclusion is applied only when its specific conditions are met, aligning with the principle of upholding contractual obligations. Incorrect approaches analysis. One incorrect approach is to broadly interpret the exclusion to cover any claim involving competitive advertising, regardless of whether a specific advertising idea or style was misappropriated. This fails to respect the specific limitations of the exclusion, which is intended to apply to a narrower set of circumstances. It risks improperly denying coverage for claims that, while competitive in nature, do not involve the theft of a proprietary advertising concept. Another incorrect approach is to automatically assume coverage exists simply because the claim involves advertising. This overlooks the potential applicability of specific exclusions. The specialist has a duty to investigate and apply relevant exclusions when the facts warrant it, rather than defaulting to coverage without a proper assessment. A third incorrect approach is to rely solely on the claimant's characterization of their injury, without independently analyzing the factual basis of the claim against the policy's exclusion language. This abdication of analytical responsibility can lead to either unwarranted coverage or improper denial, failing to uphold the specialist's duty to accurately interpret and apply the insurance contract. Professional reasoning. Professionals in this role should adopt a systematic approach. First, they must fully understand the allegations made by the claimant. Second, they must meticulously examine the relevant policy language, paying close attention to the precise wording of any exclusions, particularly the misappropriation of advertising ideas or style exclusion. Third, they must conduct a factual investigation to gather evidence that either supports or refutes the applicability of the exclusion. Fourth, they should consult relevant legal precedent and regulatory guidance to inform their interpretation of the policy terms and the facts. Finally, they must make a reasoned decision based on this comprehensive analysis, documenting the rationale clearly. This process ensures that coverage decisions are fair, consistent, and compliant with contractual and regulatory obligations.